Welcome to those of you who are just joining us for this first roundtable entitled The Unitary Patent and the Unified Patent Court, How Businesses Will Benefit. We are going to give the floor to our speakers and our moderator, Jean-Christophe Rolland, in a couple of seconds. Before, let's have a look at this video. And our panel is with here. Let's welcome our moderator, Jean-Christophe Rolland, President of the National Company of Industrial Property Attorneys. Jean-Christophe Rolland, you have the floor. I'll come back later for questions. Thank you, Asha. I am particularly proud to be the moderator of this first roundtable of the day. As you've understood, we will talk about UPC, Unified Patent Court, and a unitary patent. What are the benefits for companies? I'd like to thank the INPI for the organization of our conference today. I'd like to thank the different ministries that are supporting today's conference. Our roundtable plays a key role in today's reflection. According to today's theme, we are addressing intellectual property and economic recovery. It is a timing issue, and if you are following this topic closely, on the 19th of January, the Provisional Protocol for this new Unified Patent Court has been voted. It's the launch of the preliminary stage for the launch of this new court. This roundtable, of course, is also timely due to the context. How can we organize our economic recovery? How can we promote it? Through innovation, partly through digital transitions, climate transitions, more particularly decarbonizing our economy. For innovation to progress, we need patents. And for patents to be efficient, we need a system that can be bold and visible through courts. And this is why the UPC, the Unified Patent Court, is going to occupy a predominant position. And this is my prognosis for the upcoming years. I represent attorneys, and they were involved straight from the beginning with the other stakeholders of the intellectual property ecosystem to promote this initiative of creating a unified patent court. We have organized hearings or mock trials, mock hearings to show how this court was going to be organized. We have also presented these processes to public authorities so that we can then create this court, and we are thrilled that it is now the case. And to go deeper in this topic, I'd like to present our panel in order. To start with, Margot Fröhlinger, former Principal Director of Patent Law and Multilateral Affairs of the European Patent Office. She will address the way this Unified Patent Court has been defined by taking into account the needs and the way users want to be able to take advantage of this court. Alexander Ramsey, chairman of the UPC Preparatory Committee. Currently, he's working hard since he's the one who's in charge of launching this patent court, this unified patent court, and he was able to take some time to present the way this was going to be rolled out. Then Jérôme de Brul, who is going to tell us about the unitary patent. He was in charge of this unitary patent within the selection committee. We'll then listen to Édouard Trépose, who is an academician from University Paris 1 Panthéon-Assas, who is a professor in international law, and he will give us the academic point of view, perception of the text. And then we'll give the floor to the future users, Géraldine Guéry-Jacques, who is in charge of intellectual property at the ZED group and chairman of the Association of IP Specialists in Industry. She represents experts who are working on intellectual property issues in the industry. And to conclude with, we'll listen to Thierry Sueur, who's the chairman of UJUB, the association that was bringing together the stakeholders of our ecosystem. Without further ado, I'd like to give the floor to our panelists, starting with you, Margot.
Thank you very much, and good morning, ladies and gentlemen. I'm very pleased and honored to speak at this important conference, although I have to say that the circumstances are a little bit difficult. Ladies and gentlemen, the Unitary Patent and the Unified Patent Court are both quite unique in their legal construction. The Unitary Patent is created by 2 EU regulations, but contrary to the EU trademark and the EU design, it is not an EU title. It is simply a European patent granted by the European Patent Office under the rules and procedures of the European Patent Convention, and unitary effect can be attached to it after grant. The Unified Patent Court, on the other hand, is very closely linked to the EU legal order, but it is created by an international agreement and designed as a court common to the participating member states without participation of the EU. To understand the reasons for these unique legal constructions, we have to look at their history. When at the beginning of 2007, the Commission launched a new attempt to create a single patent and a single jurisdictional system for Europe, we looked back at a very long history of failed attempts, a history which dated back to 1949. We looked into the reasons for these failures, and there were a variety of reasons. Some were of a political, some of an economic, some of a financial nature. But the most important reason seemed to us that there was a lack of sufficient support from the users of the patent system for the previous texts. The previous texts had been agreed at political level, but had failed to meet the users' needs. And thus it seemed very important, first, to design new proposals in close cooperation with the users, to make sure from the beginning that the users' needs were really met. And second, it seemed even more important, to defend the users' interests throughout the political negotiations and to resist any political compromise which would not meet this objective. And so we did. We started with designing a new jurisdictional system, because there was one thing which the users had made absolutely clear: a single patent could not work without a single court. And this single court would have to be a supranational, specialized patent court. The users had in particular very strongly opposed the idea of creating specialized chambers for patent litigation at the European Court of Justice, as had been proposed previously by the Commission in 2003. The users had made it very clear that they wanted to have only judges experienced with patent litigation. They wanted also technically qualified judges. They wanted a simplified language regime, and they wanted tailor-made rules of procedure. And all this would have been difficult, if not impossible, to achieve at the European Court of Justice. Work on a new jurisdictional system was launched under the Portuguese presidency in 2007. It soon resulted in the first draft of an agreement on a European and community patent court. Initially, it was envisaged to create this new patent court by a mixed agreement involving not only the participating member states, but also the European Union. A breakthrough on the main features of this court was achieved under the Swedish presidency at the end of 2009. Another milestone was then reached by the Belgian presidency in the second half of 2010. The focus of attention now shifted again to the second leg of the package, that was the community patent. And in this regard, the number one controversial issue was the language, or better, the translation regime. Some member states requested translations into their national languages with legal effect, but this was not acceptable to the users. All attempts by the Commission and by the Belgian presidency to find a compromise failed. And in the end, the Belgian presidency made a very courageous and ambitious proposal, which was to go ahead with a limited number of member states by means of enhanced cooperation, something very new. The idea floated by the Belgian presidency very quickly gained momentum. Each week there were one or two more member states who announced that they would participate. And there was a lot of excitement and enthusiasm because there was finally a way out of a decade-long deadlock. However, the very day before the decisive council meeting took place in March 2011, the council meeting at which the formal decision to go ahead with enhanced cooperation was due to be adopted, the Court of Justice of the European Union poured some cold water on our enthusiasm. The court issued an opinion according to which the draft agreement on the European and Community Patent Court was incompatible with the EU treaties. This opinion had been requested by the Council back in 2009, but hardly anybody expected it to be negative. When it was issued on the very eve of the decisive council meeting, there was first some panic, some real panic. But after a careful analysis of the opinion, it became clear that the court's concerns could be remedied by designing the jurisdictional system in a different way. And thus the decision to launch the enhanced cooperation could go ahead as planned. In the following months, both the text on the community patent and the European and Community Patent Court underwent some major changes. As a result of the opinion of the European Court of Justice, the European and Community Patent Court was transformed into the Unified Patent Court, designed as a court common to member states without participation by the EU, but with very strong safeguards concerning the primacy of EU law and the role of the Court of Justice of the European Union. And second, the concept of a community patent was abandoned and was replaced by the concept of the European patent with unitary effect. The initial concept of the community patent as an EU title had been based on the idea that the EU would accede to the European Patent Convention. But such accession was not possible anymore in the context of enhanced cooperation. And in order to rely nevertheless on the EPO, not only for the grant, but also for the administration of the patent, the concept of the European patent with unitary effect was born. This is how we arrived at the Unitary Patent and the Unified Patent Court by going for what was politically and legally feasible while meeting as much as possible the needs of the users. And both the Unitary Patent and the UPC, as a result, are unique in their construction. And maybe they are not perfect. From a purely intellectual and academic point of view, one could imagine alternatives. But the Unitary Patent and the Unified Patent Court, as they stand today, should not be compared with any purely theoretical and hypothetical ideal system. They should be compared with what we have today, a fragmented, overly costly and complex, legally incoherent and risky environment for patents and for the protection of inventions in Europe. And it is for all of us now to make the best of what we have on the table. And how to do this precisely will be addressed by the following speakers. Thank you very much for your kind attention.
Merci beaucoup, Margot.
Thank you, Margot. Our history and the system that you have defined and reminded us of are showing that the stakeholders are willing to make it work, to launch it, and now that we have started the process, we must indeed understand how this preparatory phase is going to roll out. Alexander, you have the floor.
And many thanks to the French presidency of the European Union and to the INPI and to the rest of the French administration who have organized this conference. And what an excellent timing, as has been told previously, the Provisional Application Protocol entered into force just 2 weeks ago. And this is indeed a very special mark, since it means that the UPC as an organization is born. And for me personally, this has been a long-standing goal, and I must underline that this is a huge achievement for all those dedicated people who have been working very, very hard to get here. I also believe that it carries evidence that Europe has the power and will to push for innovation and economic growth in the future. I have been leading the work of the Preparatory Committee since it started in 2013, first as the Vice Chair and then as the Chair. The committee started in 2013 and it was given the mandate to establish the UPC without any undue delay. So here we are now 8 years later. I must underline that already in 2016 we were able to report to the member states that the work of the committee was done and we were ready to move into the next phase of provisional application. But you all know what happened. We were hit by the Brexit and then with 2 legal cases before the German Constitutional Court. This has meant years of delay, of course, but we have tried to use the time wisely. So already back in 2016, when we thought we were going to start on the first occasion, we put together 5 different teams. We split them into 5 different segments. It is IT, it's human resources and training, it's registry and it's corporate functions, and it's of course finance. The team consists of about 20-25 people, And they are really the boots on the ground that will cover the gap between the preparatory phase and the phase when the member states have provided the staff of the court. And they have been and are now doing the really nitty-gritty stuff. For instance, going through different workflows of the court, checking whether the secondary legislation that has been agreed in the committee actually functions together with the IT environment, planning the logistics for the interview process for the judges, developing and fine-tuning the IT systems. It needs to be underlined. We have also had workshops directed towards the future staff of the court provided by the member states, where they are getting to know each other and getting to know the environment of the UPC. So we are about to we have stepped into the provisional application phase. So what can we expect to happen during this hugely important phase? This is the pilot phase of the court, which was overlooked when we negotiate the agreement, but it was solved by the means of the protocol, and the protocol means in real terms that we will be able to apply the institutional, financial and organizational provisions of the UPC agreement provisionally. It will provide us with an organization, but we are not having to open up to the public and provide judgments just yet. During this phase, we will be able to complete some of the processes that we have started. For instance, and the most challenging one will be the recruitment, the finalization of the recruitment of the judges. And there will also be an extensive training program for the judges and for the rest of the staff. We deem that we will need at least 8 months to achieve what we need to achieve during this critical period. This is a minimum. We believe that we have an obligation to work as quickly as we can. On the other hand, we will not trigger the entry into force of the UPC agreement and the end of the provisional application phase until we are confident that we indeed have a functional court. So I mentioned the judges. This brings us to our core business. I would say that the success of the UPC hinges on its judges. We need and we want to attract and get the best possible patent judges in Europe. If we have that, then I am convinced that the court will be a success. And during the provisional application phase, we will be able to start and to conduct the interviews. We have approximately 1,000 candidates. We will recruit approximately 100 judges, 50 technically qualified judges and 50 legally qualified judges. That means that we will have to do between 200 and 300 interviews. This will, of course, be quite a logistical challenge. The advisory committee of the court will be in charge of the interviewing, and the judges will eventually be appointed by the administrative committee. And it's not until we have the judges, then we can finalize the recruitment of other key persons in the organization, such as the registrar and the deputy registrar. And it's not until we have the judges we can have president elections, a presidium, and so on and so forth. So quite a lot of the work processes that we need to conduct during the provisional application phase also depends on the recruitment process. So the imminent next step that will happen now, it's already been scheduled to the end of February, will be the inaugural meetings of the 3 committees that will be governing the organization: the administrative committee, the advisory committee, and the budget committee. There will be election of chairpersons. The administrative committee will also appoint the members of the advisory committee, who will be appointed in their personal capacity. And as I said previously, it's these persons who will be in charge of the interview process for the judges. There will be also the adoption of the budget of the court for the provisional application phase. Last but not least, a few words on the life science division that was supposed to be in London before the Brexit. Now it's obvious that there will be no section of the court in London. There will be no presence of the UPC in the UK. So, of course, there will not be a section of the central division for the court of first instance in London. The signatory states will need to decide where to reallocate this division. However, I would like to emphasize that this is no need to delay the start of operations of the court. The existing seat which will be in Paris, as you all know, and the section in Munich will be able to deal with all the cases until this issue has been settled. And there will be transparency also where the different patent cases will go, because that can be settled with the decision in the administrative committee, so that there is transparency on that issue as well for the users. Now, my team, we are very happy to have progressed this far. We are also fully aware that there remains a lot of work to be done, but we are eager to pull up our sleeves and just get it done so that we, as soon as possible, can open up the doors of the UPC to the public. Now, thanks for your attention.
Merci beaucoup, Alexander, pour toutes ces précisions.
Thank you, Alexander, for these precious information. We have a lot of work left to do, so good luck. And I'd like to comment on something you said before I give the floor to Jérôme. The fact that the central division is going to be located in Paris. You saw it in our short video introducing our panel. We chose the Palais de Justice on the Ile de la Cité. It's a beautiful symbol, beautiful signal of France's commitment to this project. Jérôme, you are now going to tell us about this system, and you're going to tell us about the Unitary Patent.
Merci, Jean-Christophe. Mesdames et messieurs.
Thank you, Jean-Christophe. Ladies and gentlemen, good day. It's a pleasure and an honor for me to have the opportunity to present to you the current status of the unique patent. I think I've already had the opportunity of presenting this status at least 10 times. However, the first time that it can be presented at a time when the actual rules are coming into force that created it. It's never been as certain as it is now at its close, since it was adopted in December of 2012. So where do we stand today? As you know, probably, the essential of the unitary patent, as well as the financial aspects, notably the amount of taxes and the distribution of the share of revenue to various member states in participating in reinforced cooperation, was decided in December 2015 by the Reduced Committee. This was established in the European Patent Organization through the member states of the European Union that participate in the cooperation in terms of unitary patents. Well, when the dynamic of this entering into force in June of 2021, subsequent to rejection by the Constitutional Court in Germany and the complaint, therefore, the Restricted Committee in October decided to take stock on the measures that needed to be taken before June of 2022 so as to be ready for the entry into force of this in the second half year of 2022. From the financial point of view, we had to adapt the actual distribution to adapt to Great Britain's exit. This was done in December of 2021 through mathematical adaptation of the mathematical calculation, which consists in redistributing to the European Union the share of Great Britain proportionately to their initial share in that distribution key. So the EPO and the European Commission and the member states and user associations. So this coordination was essential so as to give a key message to users of the European patent system, the PME, the universities, the research centers, about the characteristics and the benefits of this reform. In conclusion, the implementation of the Unitary Patent is almost concluded. So the new tool for supporting innovation in Europe is at last ready to be available to users. What are the main advantages of this compared to the current situation? To my way of thinking, there are 5. The first advantage is the flexibility. They will open a new possibility for European patent holders. Currently, patent holders can validate a European patent in one or several or all of the 38 contracting states of various European offices of patents. After application of the reform, the patent holders may decide, if they so wish, to have a unitary patent for the 17 member states of the European Union that are participating in the reinforced cooperation and that will be bound by these agreements when they enter into force. The second advantage is the geographical coverage. Today, there are 75% of European patents are validated only in 4 contracting states currently, generally Germany, France, Great Britain, Italy. The unitary agreement will have a centralized system that would be easily accessible to all of the 17 members of the European states. Potentially, this unitary effect could be extended to the 25 member states that participate in the reinforced cooperation, when the 8 member states that have not done so yet will have ratified the agreement on this jurisdiction. And why not? Ultimately, to all 27 members of the European Union. This will make it possible to dispense with the current processes substantially in the internal markets in Europe. The third advantage is improved legal security. This results from several major modifications. First of all, the unitary effect of itself. They will provide a uniform protection and shall have the equal effect in all of the participating member states. The scope. The second modification, which was very difficult to set out, since, as Marco indicated, it could only be obtained by having recourse to reinforced cooperation without consistent providing that the European Pact had a unitary effect, would have these effects with respect to all members of the European Union participating in one single language, i.e., the official language of the office in which the patent is being delivered. It would be in English, French, or German. The third modification, which was not easy either, and which was just presented, was the actual patent itself, the unified system in the European level to settle litigation for infringements or revocation of the unitary patent. So it's a structural, offered a legal security that's increased compared to the current system. The fourth advantage was this administrative simplification, whether it be for registering or payment of taxes or publication of the information on the status of the unitary patent. Only one procedure to follow, instead of the very many and diverse procedures that must be accomplished on the national level, which also means that there's a reduction in the cost of representation. The fifth advantage, and nonetheless, is the level of a tax which will be more attractive to be a reduction of cost compared to the current system. On the one hand, the submission taxes, registration taxes. In addition, their translation and representation taxes will be reduced. And the maintenance renewal is attractive for users. Because for a given territory corresponding to 17 member states and possibly 25, it would correspond to the amount of tax covered for the 4 states where they're currently validated since 2015. So that would be less than 5,000 euros to maintain a patent for 10 years, which is the average duration of the patent. By taking into account the interests of the companies, the office will be implementing 2 transitional measures so that users can perform their procedures in either system before entering into application. So as to benefit from this, it will be so prejudice to remove the possibility of having a unitary effect because it had only been delivered just before the entry into application. In other words, 3 or 4 months prior to the entry in force. The first measure of transitory nature will be the possibility to have an effect of unitary application prior to registering, and it would take effect immediately upon the approval. The second would be the possibility for the requester to submit a request to have a European patent until the starting up of the new measures. So this is only going to be possible under certain conditions, and it will disappear, obviously, once the new regime enters into effect. You can find a description on the site giving the details of these transitional measures. That's where we stand briefly on the Unitary Patent. There are significant advantages which explain why it's a major reform, and also why it took so long to set up this reform at last. Thank you for your attention, and we are available for any questions you may have. Thank you.
Merci, Jérôme.
Thank you, Jérôme.
Merci à
Thanks to all three of you who intervened remotely and who, as we understood, are still very much involved, such that the system starts up in the coming months. Now we're going to move to the set with all of the participants that will be with me here to submit the new system to your criticism or comments as university and future users.
Donc, Edouard, je vous passe la parole pour la vision académique.
For the academic view. Thank you.
Jean-Christophe.
Thank you, Jean-Christophe.
My
point is that, and we've seen this clearly with the various interventions, that the unified patent is balanced between standards of various levels, between international law, European law, and national law. And to understand the unitary patent, we have to go back to the initials, to the principles of intellectual property. It's an immaterial and therefore ambiguous. Now, this ambiguity requires very quickly to be confronted with borders and to seek protection beyond this national framework. Before, it used to be a privilege, and then it became multilateral with the Paris and Berne agreements. So we understand already the national standards that protect, and also the need for international standards. And then came Europe, and the source is international. And the Convention on the European Patents and the Union law rules are regional. And so it's between national and international standards. So it's particular. And there has to be an overlapping of these standards. So based on the protection purpose, the reasons are not exactly the same. Margot earlier was speaking about the right of trademarks, and in trademarks, you have an intervention by the European law, which right from the beginning is a very strong law, with a harmonization directive, which takes into account all of the contributing factors to trademark law. But it's not the same in patents. You have the European Convention on Patents, which are the 38 members. It's much bigger than Europe, in fact. It's an international text. And you need to build with these different parts. So if you're trying to construct an European, based on trademarks, we're copying and pasting the substantial aspects of the directive into this document. So when you're trying to find a unitary effect in terms of patents, what actually exists is not the same. It's the BCE, ECB. We are basing this on the EC, based on Article 142, which provides for a unitary effect. So we need to take into account what is existing to understand the system that's being created. And the one that's being created is based on the success, indubitable success, of the European patent, and to prolong this success, as the European patent had already planned under Article 142, and you also see this in the first article of the Alinea 2. This is a particular arrangement along along the lines of the CE. You see this under the JUB agreement, and in this sense, the JUB will have to rewrite or adapt this, which is complex, but it's very clearly stated in this article, and we have the CBE. So we are basing this on things that have been acquired and acquired in other areas. So what do we observe? For the brands of European Union, we observe in technical assets, it's a question of property. And European law says nothing about this, so we have to fill in this gap. So how do we fill in the gap? Well, by assimilation of the brand of the Union to a national brand, what we would call a kind of conflict regulation about the questions of property. They might be assimilated to a French brand, and so we would solve the problem in this way. So we would do the same thing about the Unitary Patent. Article 7 of the regulations on this point is the equivalent to objects, sensitivity, guarantees, effect with third parties. Is the same thing we're already familiar with in the context of the European Union trademark. It's a cascade, which makes it possible to apply French law. In China, if they have an establishment in France, it would be French law. And if there's nothing that makes it possible to attach this to a given participating nation, it would be German law. As the same for the brand, it would be the Spanish law because of the position of IPO. So all of this is classical. Maybe one interesting point is the indirect possibility of choosing the law. If you have two co-submitters, you'd see it would be granted to the first person having submitted. So then we can talk about Article 5 of the regulation, about questions that are linked to protection and limitation. So leaving aside the property aspect, we're getting into the heart of the whole thing, what protection is offered. Article 5 says that we need to send this back to Article 7. So my patent has a unitary effect submitted by a French person. It would be subject to French law. In the same way, if it's submitted by an Italian, it would be under Italian law. So here there would be a possibility, perhaps, for criticism. Is this really a unitary patent if it's under different laws? And the answer is simple. Pierre Véron supported this. I'm just repeating what he said in a very wonderful article. It's just an optical effect, because formally, thanks to this attachment to an Article 5 and Article 7 about the protection, it is German law that will be applicable, or the French or the Italian law. But what do you see in the French, German, and Italian laws? Article 25 and 26 and 27 of the JUB agreement. So you actually have the same articles, the same standards. So that's what underlies in national law. So the national agreement of the JUB and the international provisions that are identical. So ultimately, nothing is very new. The construction respects the past and is founded on what has been acquired. And we can perhaps improve in non-contracting parties. We could imagine that the JUB could apply Chinese law. They could perhaps do reconventional if there's a counterfeiting subsequent to the breaking of a contract for no payment of fees. So the JUB would apply Chinese law if the patent was under Chinese law. But that's classical. It's the Roman law. So all of this has been found and proven. So the construction, to my way of thinking, would be based on the past, that would prolong the past, and I share your projection is that it would be a success. In fact, I hope so. Thank you, Edward. Your intervention really does demonstrate how solid the system is. Geraldine, to move on to the heart of the question raised by this panel. What advantages are there for enterprises? The floor is yours. Thank you, Jean-Christophe. Hello, ladies and gentlemen. I am honored, and I'd like to thank the organizers who have invited me to the SPI, the Association of Specialists in Intellectual Property and Enterprises. Indeed, we are daily users of the patent system. We are both in industry and we're also professionals of intellectual property. We're in direct contact with the heart of the reactor, i.e. technical and scientific innovation. As a professional in patents, we are there to accompany the innovation strategy and support it and serve it. We work as well on a daily basis with both sides of the coin of patents. The first side is that which is the best known, the side of innovators and active users, those who invent, who protect, and who register patents. The second side is perhaps a bit less known, or not, but it still is there. These are the followers' side, whether they're aware of it or not. The people who will be reproducing innovations already patented. They might be passive users of the system or third parties. It's very important, and every company has this, both sides of this coin every day, and the future system must absolutely, the Unitary and the UPC have to be aware of the two sides of this coin and offer a system which is balanced and which is fair with respect to both sides of the coin. With respect to the current construction, I am persuaded that that is the case. That's for the spirit of the future unitary system. Obviously, there's the implementation to come, and we're going to be getting our hands dirty very soon. Today, industrials are currently thinking about this actively. Since the 19th of January, as Alexander Ramsey indicated, because it's the opening of the preparatory phase of the Unified Patent Court. So the founding texts are well known, and since 2013, there are still a few texts, such as the regulations that haven't been finalized, and we're very attentive about those upcoming texts. So we'll be having a more dynamic reflection process, and we need at least 5 months to think about it. When I talk about a period for reflection for users, it might even go a bit further. I would talk about the real requirement not only to think about it, but to revisit the strategy with respect to patents, and the need as well to participate in the construction of a system that should be satisfying to all of the users. So I wanted to give today some food for thought concerning the UPC and patents, so that we can add to and contribute to and revisit the strategy. With respect to the UPC, we know that this is going to be entering in force very soon, and we also know that it will be the system after the transition, the unique system, after the transition phase, that will be handling any litigation. So there's no question, you have to go there, we have to go there. So at a given point in time, we're going to have to adopt a posture that we're going to be testing, and I'm going to be taking it. So the testing posture and learning process, we won't perhaps not have this for all kinds of patents, but we need to have it. This transition period is 7 years renewable once. The second food for thought, for me, another level of quality is expected with regards to the decisions of this future system. We've seen in the construction, in the texts, this is a court that will have a sophisticated means of operation, but we need judges that are professional. We need judges that are specialized in patents, and judges that will be a panel of technical judges and of scientific judges. It's very important when you talk about patents, we talk also about science, that there be at least one technical judge who's able to understand the content of the patent and the technology. And if only for that, I'd like to congratulate the future UPC about that point. The third thing to think about for this UPC, and we've heard people talking about this, a few panelists before I spoke, was the geographical aspects of the decision, especially amongst the member states. So one submission concerns all member states. Now, there's one slight off note here in speaking about construction. Member states are not yet all present. Are not all present. We have known since 2016 or a bit earlier, a bit later, that we would never have Great Britain with us in the UPC. That's really regrettable because it was one of the biggest registrars of patents. And many patents were registered there, but that's the way it is. So the question arises for Spain as well, which is one of the countries where they have the most approval of European patents, in Poland as well. So the geographical effect, unitary effect is important, but we have to grow this very quickly to make it more attractive in terms of the geographical coverage. We have to make it attractive. And one other point I wanted to just underline, the speakers before me did it better than I just wanted to underline that there's a multiplicity of legal means available under the UPC. It's a whole set of best-in-class from all states and all national tribunals that have been grouped together and pooled, which will be a wonderful tool, grouping together all of the best practices. And I'm thinking about counterfeiting, about validity, but I'm thinking also about seizures, which is well known in France against counterfeiting, provisional and interdiction, and protective letter actions. Another item I wish to underline was the fact that the written procedures will be 100% digital. Maybe this is just purely a practical question, but it's very good for users to have a totally digital system, and I'm insisting on this for written procedures because we believe in this piece that it's very important when there's oral litigation at the end of the instruction period, that the oral can be conducted in face-to-face. And when we talked about cost, it's going to depend also, and here I'm thinking more about revisiting the strategy here. Today, when you want to attack a counterfeiter in several countries, often or if it's a big case, you can sue someone in several countries. But it would be better to have unitary action because it would cost a lot less. But Spain would have to not be the country that's counterfeiting. That's just an example. Another factor to think about, and my last one, is thinking about a sophisticated system. I can also speak about a complex system. Jean-Christophe talked about a brand. You have to tame this animal because they're going to have big claws. And a few factors to think about to revisit the strategy about unitary patent, unified patents. It won't be as new as you think, because the unitary patents, the unified patents, will be an additional choice at the time the decision is taken to award the patent. It's simplistic, but it means that we know the European system. We've used it for dozens of years. The quality has been demonstrated. So there's not anything unexpected. We know that the unitary patent system that we choose or not, the quality demonstrates that the quality that exists already in Europe. So that quality goes hand in hand. The quality goes hand in hand with the choice, the time you make the choice for the unitary effect or not. And that will not, we're not going to be choosing that when you're submitting. You're going to do it later on. We're going to choose it 3 or 4 years after the submission, at the time when it's granted. So we'll see, either you choose a unitary effect or a validation in European national areas, or both, because we're going to be doing both. We will already have a good idea of what is really protected and the extent of the protection of the patent which is going to be available to us. So that is a real advantage compared to the unitary system. Jérôme said it. I'm going to rewrite it. That is what the flexibility is all about in the choice for users. I choose a unitary patent with a geographical effect that's unitary, or I choose a validation of a European patent in one or several countries, or I choose both, plus the validation on a European level. You could have a validation in Spain for European patent. It's very flexible. The fourth factor to think about is the cost. And that's what it's all about, really. We talk about this a lot in industry. You have to fight with our top management about the costs. We're talking here about the cost of annual taxes. I would give one negative comment here, and that's why I think we need to revisit the strategy. Today, we're very careful about cost, and today, before the unitary system, we would choose a few countries for validating the European patent. It's public. I mean, I can talk about the company that I work in. We usually validate the European patent in 4 countries, and the cost of annuities are a cost on an average of 4 countries. For me, and for this will not be an advantage to say, if you say that I'm going to be making money. The cost needs to be secondary, obviously, in the decision-making process, but I just wanted to underline that. As well, this whole question of language. This is our history in Europe. We have many languages floating around. We already bet at the end of the 70s we thought it would be the 3 official languages. But several decades later, it's a good system, and we can, I think, go a bit further with that and have fewer languages, perhaps, and have less translation, because we're in 2022 and we have automatic translation systems which are not perfect, but which are already very good and which will improve in months or years to come, in a short time. And I'd like to conclude about geographical protection. And Jérôme said earlier that, indeed, everything that's expected of us is that there be a maximum number of member states that sign and that ratify this and that join the unitary patent, because it can only be a supplementary factor of attraction for the users and industrials. And I believe as well that the success, I'm expecting a lot from the UPC, and the success of their decisions will naturally have as a consequence the success of the unitary patent. Thank you. Thank you, Geraldine. A lot of information in what you've said. One thing that I'm definitely going to remember, even if it was all interesting, it has to do, first of all, which the profession of counsel in industrial property, in the presence of a technical judge, and what a huge interest there is in having counsels in handling these files. Thierry, without further ado, I'll hand over to you. What would you like to add, sir?
Well, I wonder, because a lot has been said already, so I'll try not to repeat what's already been said. You introduced me as a user earlier, and I will get back to the UPC. I'd like to remind that I am chairing the executive committee of the MEDEF, the French industry, and the Group for European Industry. And since we are under French presidency, you must know that on the 14th of July 1789, something quite important took place in Paris near the Bastille Square. On the 15th of July, the King of France asked one of his advisors, what happened? Is this a revolt? Is this a revolution? A revolt? And his advisor says, no, it's a revolution. And I think that's what we are going through today, is a revolution as well, and not a riot. And I think that we need to consider it as such, as users, if we truly want to understand the scope of the reform that is taking place currently. It's not business as usual. This is going to be a wake-up call, and I think that Géraldine has explained it very well. We are not going to dwell into the past too much, but to better understand the present and the future, we need to understand what has happened since 1949, as Margot reminded us of. These dozens of failures that we went through to then be able to put in place a unitary patent and a unified patent court. Agreements were signed on the unitary patent. Some conventions that were well put together by our institutions, but there were absolutely no results following this, because users, us, we didn't want it. We thought that it was useless, that it couldn't be used, and we didn't want reforms that could be perfect at the legal level, but extremely inefficient. And I think that we lost the definition of what a patent is. We didn't have it in mind anymore. We took too much time. We spent too much time talking about the hurdles, legal hurdles, linguistic hurdles, and we lost sight of what is essential, that a patent is an economic tool for a given territory, that with time the European Union had become a single market, and a single market needs a single a context, and we need a law, we need an office, we need a court, and lastly, that we need a scope. What is it for? It's for the society, for the benefit of the society, going through industrials and innovators. Why? Well, because it's a system that we think will favor taking risks, investment, and progress. We also had forgotten that we needed institutions to accept it, and that in Europe, as a general rule, we want it to be accepted unanimously or at a majority. So to sum up, our system was inconsistent. And today, we are switching from inconsistency to consistency. And we use the system put in place by the EU IPO, and it's a system that works well. I talked about it with other industrials from Japan, China, United States. It's acknowledged, it's recognized as the best system, European system in the world, and it needed to be aligned with the acquis communautaire, and we needed this single title that could match a market, a title that can be used at the global level, that is probably in favor of licensing with a broader coverage, licensing that can be applied in territories, in regions where the patent is not valid, and we needed a court that would go with it. And Géraldine has insisted on this particular point. It is not a mandatory system, it's an option that we have, an additional option that we have. So we are adding the unitary patent to this array of tools, and the people submitting applications can choose. And I'd like to thank Jérôme and Margot, because it was done under French presidency that we talked about cooperation, and without an enhanced cooperation we wouldn't be here today. Regarding the courts, the UPC, I think that, commenting on what Edouard Trépose has said, we need to acknowledge that patent-related litigations are different from other types. We see it at the international level, and it's quite probably because of the how cumbersome technology is, and we have switched from a system that is institutional to one that has acknowledged who users were and what their needs were. I talk about users, but of course I think about manufacturers, industrials, a system that is involving lawyers as well. This is based on what Europe does best, on judges that have experience. Géraldine has reminded us of it. Judges who are used to working together or to meet, like the meetings that took place in Venice. Technical judges that were required and by users, and we have built ad hoc procedural rules for this court, and of course this is part of the EU framework, and decisions can be appealed within a court in Luxembourg, and this changes the course of things. And I think that the system that is in place today, it's not a restriction, but rather it's a way to satisfy the needs expressed by the users. Is it perfect? Are there risks? Yes. It's quite likely. And Géraldine has mentioned that the UK is not part of the Unitary Patent, and it's not part of the Unified Patent Court. It's a shame for everyone, for us, because we'll have to seek protection through the international patent and through other organizations. It's a shame, but it's how it is. There are risks also that users, and by listening to Géraldine, I am not worried that users stay outside of the system. But let's remember that when the European patent was created, Europeans themselves were quite cautious, and I think it was thanks and because of Americans or Japanese people that we woke up and we thought, okay, they're going for it, we need to go for it as well. Let's not forget about this, and let's not be cautious as they were. We need to understand that it's not like putting our eggs in one basket. I must say that I'm quite put off by this expression, because I don't think that us as manufacturers, we are lobbying in the US to have a patent in California, in Massachusetts. It's a coherent region. It's the same in Europe. It's a market. There will be a unitary patent. It is logical. And we had a choice. Patents are sometimes not validated, but they are also approved. And to have a unitary patent that is approved by the court will carry a weight, will be accepted, and this consistency between the market tool, there's a registration procedure that has been approved, a decision that is made in agreement with the European patent, so we can make a decision years later, when the European patent has been granted, and then we will be able to wonder if claims are interesting. Is it an important patent, commercially speaking? So it is an opportunity. And we need to remember that we have just gone through difficult times due to COVID, and that Europe has just invested billions of euros to invest in recovery from COVID, in environmental transition, digital transition. 50% of this amount is dedicated to R&D. So it's a great opportunity. A new tool is available. Huge amount of money are available. The same for the court. We need to remember that even if we limit to 13 member states the unitary patent and the UPC, our market represents 10,000 billions of euros, and in the next few years the size of this market will be similar to the US and China. So this is a significant opportunity, and the UK is not part of it. It's a shame, but it's still an opportunity. And the legal system is also important, and to really understand that it is an opportunity, we need to remember that the opportunity, the advantage is to the attacker. We need to use the system, we need to train people. Europeans have a responsibility in this system. And I'd like to highlight the geopolitical level. Today, the European patent has some gaps. It looks a bit like a Swiss cheese, because tomorrow, thanks to the unitary patent and the court, we will be one block facing our competitors. To go through Europe, you'll have to go through our UPC, which is an advantage, because currently we're going through our national courts, and users are going to be responsible. And I'm going to talk about the Union for the Unified Patent Court, an association that was created in 2013 and that brought together the whole of the French intellectual property system, industrials, the MEDEF, SMEs, the French Committee, and the International Trade Chamber. So lawyers, French lawyers, lawyers specialized in intellectual property, the ASPI as well, specialists in intellectual property and industry, and all the associations that we know, the Friends of the CPI, the PEB, and others. And I apologize if I've forgotten some people. So all these people were brought together for a reason. We thought it was a timely moment, and France, up to now, didn't benefit from a position in terms of intellectual property. And what did we do in France? What do we do, and what are we going to do? First of all, we were the contact point with public authorities. We started an inquiry to identify European needs, not in France, but in Europe. And I'd like to get back to the video we watched earlier. The investigation showed that European users and the ecosystem wanted the location of the headquarters to be accessible in terms of transportation. And we thought that near the Palais de Justice. The access is quite easy coming from the airport, Roissy. And we asked for many years for the Palais de Justice to be chosen, not because it was a prestigious place, but because it would be a good candidate, a good place. It took time because we received no answer until now, and we started asking about it in 2013. But I'm happy that the answer was positive. And we have also organized 3 mock trials with German, French, Polish judges, with attorneys in intellectual property, lawyers from different nationalities. The last one gathered 1,500 people in all of Europe. We'll probably have to organize more of them. And I must say that, yes, the German appeal may just lose momentum a bit, but I'm not worried. And we also organized in different organizations some mock trials as well, so that we can be trained at the legal level, so that we can take ownership of this, that we have strategic meetings to exchange ideas. And I think today that French people, and I'm sure it's the same in other European countries, that French people want to be ready, will be ready to seize opportunities. Jean-Christophe, we are now reaching the end of this roundtable. Maybe we can briefly ask one question. I think it's addressed to Margaret. I'm going to ask it in English.
That the history of attempts to create a single patent and a single jurisdiction system dates back to 1949. So the question here is, why did it take so long?
There was a variety of reasons. In the early years, in the 50s and in the 60s, there were issues of national sovereignty. But these issues faded away with the progress on European integration. Then the language issue came up, and the language issue became ever more important the more member states joined the European Union and the more languages we had. Then there was a financial issue of the distribution of the renewal fees among member states. There was also some strong resistance, for instance, from some national offices in some member states, from parts of the professions in other member states, also from some big multinational companies who live very, very well with the current fragmented system because they can use this against their small competitors. But I'm absolutely convinced that the #1 reason was that, on the one hand, at political level, there was no real understanding about the macroeconomic importance of creating a single patent and a single jurisdictional system. And on the other hand, therefore also, the politicians agreed on texts which were politically feasible, but which did absolutely not meet the user's needs. This was, for instance, very obvious in 2003, 2004. There was an agreement at highest political level by the heads of government at a European summit. And very shortly afterwards, it fell apart because the users were utterly disappointed with the compromise, and they rejected it, and they criticized the governments in some countries very vigorously. And so it did not materialize. And I think the game changer was really when the European Commission started to work together with the users and to defend the interests of the users.
Thank you for sharing, Margot. Things have changed, hopefully. Jean-Christophe, I think it's time to say thank you to our panelists. That's all the time we have. So, je repasse en français, je te laisse faire.
I'll switch back to French, and so you can thank the panel members, and that's all we have time for. So thank you very much to all of you. I think your comments, explanations showed us that we have co-built a new system, and there will probably we'll need a new revolution so that we take ownership of it. Thank you to all our panel members. Thank you to all of you who have listened to us. We will be back for the rest of the agenda. If you're on our website, you'll be able to see who are the winners of the INPI trophies. Thank you very much.